Good afternoon. This is Daniel Bornstein. Welcome. Happy belated New Year. Once again, we're in a wonderful opportunity to do some great learning as the time evolves and we all get older. Unfortunately, landlord-tenant law in the Bay Area in California becomes even more and more complicated. But you're lucky because you've made a decision to self-select into this 1 hour working webinar. And my hope for all of you is that we come away with a better working knowledge of the law and that everyone is ready to do some good learning. Because of the volume of the information, I'm going to not take questions, but I'm going to go through this slide presentation. I will thereafter distribute the slide to all of you, and should you have questions, you can of course email me. I'm Daniel Bornstein. I've been practicing law for now over about 30 years, and my fundamental responsibility is helping to educate people about landlord-tenant law. I represent property owners, housing providers, brokers, property managers, and handling and migrating this complex world of landlord-tenant. What I'm going to do today for all of you is to go over some key new laws, do some learning on state rent control, state just cause eviction rules, have a little bit of focus on the local ordinances, and hopefully put you in a position where if you look at a dispute or have a landlord-tenant issue, you'll be better able to understand the complexities that you face when trying to ascertain what is the best strategic approach to handle a dispute. So with that, let's go over the agenda. Again, I'm going to give you an overview of rent control and just cause eviction protections, a summary of AB 1482, which is the state rent control just cause eviction ordinance, go through some of the new laws that are in effect as of 2024, focus on some of the local laws, talk about some of the processes for evictions, discuss what we're confronting right now in the courts and with evictions, and then talk to you about, in the end, the strategies involved in trying to accomplish goals for your property management clients, so that you're making best decisions in light of what you face when confronting difficulties in housing providing, which is a people sport, which can often be very, very stressful for everyone. It is particularly stressful when you don't have a working knowledge of the law, or you don't have a go-to attorney who can provide you some core guidance as your dispute evolves or arises. So with that, let's begin. When we talk about a property or California or a building and we say, oh, the building is subject to rent control or state just cause eviction rules, I want you to remember that there are two components of the law that you need to be familiar with. There is rent regulation and there is eviction protections. And right now in California, we have a state just cause eviction ordinance and a state rent control ordinance. And as many of you know, living in the Bay Area primarily, there are local ordinances. And when we say, oh, the property is subject to Berkeley's rent control law, we're often really saying it's subject to rent control and just cause eviction protections. Rent control is the basis by which you can raise rents, how often they can be raised, and what are some of the exemptions under the rent ordinance, and some of the obligations regarding disclosure, registration, and how rent control will be impacted by a local ordinance or not. Just cause eviction protections are different. Just cause eviction protections are under what circumstances you can end a tenancy. Whether you have at fault just cause, such as non-payment of rent or breach of a lease, or no fault evictions, which are, it's no fault of the tenant that they're being asked to leave the premises, such as an owner move-in termination, a relative move-in termination, a substantial rehab of the property. And on top of this, you have to be familiar with that there are some types of no-fault terminations that require relocation payments. So as you look at a building, you're always going to ask yourself, where's the building located? Is it a single-family home, a condominium, or a multi-unit property? When was it built? And when I have that information, I can then say, oh, it's subject to state rent control, state just cause eviction rules, or alternatively, I can say it's subject to the San Francisco rent control ordinance and San Francisco's just cause eviction ordinance. If the property is a fiveplex that's 1950s construction built in Walnut Creek, I immediately can say, oh, it's subject to state rent control and state just cause eviction rules. It can get pretty complex in certain circumstances because there are certain properties that may be subject to just cause eviction rules, but not rent regulation. For many of you, the important thing is at least to understand the property you own or the property that you manage, understanding what ordinance it applies to and if it is exempt because of some particular aspect of the property. So remember, when we look at a property, we're always asking ourselves, is it subject to rent control? Is it subject to just cause eviction protections, whether it's under the state ordinance or whether it's under a local ordinance? The key points in the state ordinance is that there is a cap on rent increases, 5% plus the local CPI, not to exceed 10%. There are just cause eviction protections that kick in when a tenant has lived in a premises over 12 months. There are relocation payments for no fault termination. So if I own a property, for instance, in Walnut Creek, and it's a 5-unit property, and I want to move into the top unit, I have to follow the rules of the state ordinance, and I also have to provide a relocation payment equivalent to 1 month's rent. If the property in California is under 15 years of age, it will be exempt from the state just cause eviction ordinance. Also, typically, single-family homes and condominium units are exempt from the state ordinance. However, remember, there are some exceptions to that. If that single-family home is owned by a corporation, a real estate investment trust, or an LLC where one member is a corporation, then it will not be exempt. And this is where things get tricky. And that's why I always invite you, if you have a situation where you're looking at a property or you're considering taking on a client's property for management, contact me and we'll go over whether the property is exempt, whether the property is not exempt, whether the property is subject to the more restrictive local ordinance or not. I go through the filtration process whenever anybody contacts me. And if you look at my client intake forms, I'm asking you questions in that intake form in order for me to identify under what ordinance and what restrictions that property is subject to. 1482, again, is the state ordinance. If you own property in Oakland, you're likely subject to the local ordinance. If you own property in Berkeley, you're likely subject to the Berkeley ordinance. If you're owning property in Richmond, California, you're likely subject to the Richmond ordinance. When I started 30 years ago, there were about 3 rent control just cause eviction ordinances in the Bay Area. We had Berkeley, we had Oakland, we had San Francisco. Now there's about 13 or 14. It's only going to get more complex as time arises. As you know, housing is very politicized, and tenant advocacy groups are actively seeking to have local ordinances embedded in cities to make it more difficult for home and housing providers to have the ability to accomplish goals without this sort of over-regulated environment of a rent control ordinance or a just cause eviction ordinance. Now, as of 2024, AB 1482 went through a couple changes. The first one is, if you are intending to do a substantial remodel, you need to have the permits in place, and the notice must have the permits accompanied with it. The tenant must also be informed that they have the right to reoccupy the unit after the remodel is completed. Prior to 2024, substantial remodels were relatively an easy endeavor to serve a termination notice with under state law. You needed to allege that you intended to do a substantial remodel. You didn't have to attach the permits. And so it was a much easier termination. As of 2024, the law has been tightened up. Also, for no fault eviction of an owner move-in or a relative move-in, it now is required under state ordinance that the owner or relative must reside in the unit for at least 12 months. Prior to 2024, there was no delineation in the statute as to the time period that owner needed to live in the premises. Now, state ordinance, state law, state rent control is less restrictive than a local ordinance. When you have a local ordinance and your property is subject to the local ordinance, it's because it's more restrictive. For instance, in San Francisco, in order to do an owner move-in eviction on a property subject to the ordinance, you have to promise to live there 3 years. The relocation payment under the state ordinance is the equivalent of 1 month's rent. The relocation payment under the San Francisco ordinance is $7,500 per each authorized occupant. If there are 3 occupants who have lived there over a year, it's a $22,000 relocation payment. Which ordinance is more restrictive, San Francisco or the state ordinance? Of course, San Francisco. Walnut Creek has it easier. They don't have a local ordinance. San Francisco has a local ordinance. Your job is to know when you're looking at a property to purchase, you better know if that local ordinance is in place and whether it's more restrictive or not. And it's your job as an investor to make sure you have a working knowledge before you make that decision to purchase. Because if you purchase a property with expectations that you're going to do certain things with the tenants, and then someone taps you on the shoulder and say, I'm sorry, but you're subject to a local ordinance, you're going to be very, very disappointed because you probably overpaid for that property. Because we know properties are not just valued based upon how much it will cost to replace it. Properties are based upon what you can and can't do, and that includes rents, rent increases, cash flow coming out of the property, and that is directly related to what the statute and rules are relating to that particular rent ordinance. So for you folks who are involved in purchasing or selling property, you're going to have a working knowledge of the ordinance. Let's move on right now to the new state laws that have impacted housing providers. First, security deposits. Many of you walk around knowing that, hey, I can ask for up to 2 months rent for a unfurnished unit and up to 3 months rent for a furnished unit. Well, the law changed as of July 1st, 2024. There is no distinction between furnished and unfurnished units. And what you need to make sure of is that you walk around with an understanding that the new law, the general rule, is 1 month rent equivalent for a security deposit. There's a lot of nuances in this law, and as I pride myself in making sure that I take complex information and make it digestible for you folks, I've created a cheat sheet for the security deposit new law that becomes effective July 1st, 2024. Why don't we take a look at it? So here is the cheat sheet for you folks in order to figure out whether you can ask for no more than 1 month's rent or you're entitled to no more than 2 months rent as a security deposit. The first question you ask, is the landlord a natural person, an LLC, which all members are natural persons? If the answer is no, then you're only entitled to 1 month's rent. So if the property is held by a what? A corporation, 1 month's rent. If the property is held by an individual like John Jones, the answer is yes. You go to the second part of the chart on the left-hand side. Does a landlord own more than 2 residential properties that collectively include more than 4 dwelling units offered for rent? If the landlord only owns a single family home, then the answer is no. Move on. Is the tenant actively serving in the military? No. In that situation, the landlord is entitled, or the housing provider is entitled, to ask for 2 months rent. So if you, Jane Doe, own a single family home and it's the only investment property you own, you're still entitled to ask for 2 months rent. However, if you, Jane Doe, owns a 10-unit property, even though you own it in your own name, you own more than 2 residential properties that include more than 4 dwelling units, and therefore security deposit 1 month's rent. If you find out your tenant is actively serving in the military, then it's a 1 month rent. It doesn't make a difference. 1 month's rent if the tenant is actively serving in the military. My hope is that you use this security deposit cheat sheet so you don't get yourself in trouble. Again, there's complexity to this, but this is the general approach you take to determine whether you can ask for up to 2 months rent or 1 month's rent. This law becomes effective July 1st, 2024. Please don't make a mistake and violate the law, because remember, there are brilliant tenant attorneys looking to take advantage of your ignorance and turn around and hold you financially responsible for the mistakes you make in good faith, but are still violations of the law. Most of my clients who make mistakes, they're lovely people. They still get sued and have to pay sufficient payments to resolve the matter because they were not aware of the law. They only came to me after the fact, after they've been sued, and it's too late often to undo the error they made. Here's another issue. Let me give you the example to help clarify. You rent or are offering a rental unit for $1,000 a month. A prospective tenant applicant tells you that they have a voucher from the San Francisco Housing Authority for $800 a month. So if the rent is $1,000 and the voucher is $800, the tenant only has to pay how much each month out of their own pocket? $200. In that situation, you are not entitled to use the tenant prospective applicant's credit history if they have a subsidy. What you need to inquire is that you must give the tenant an opportunity to produce legal, verifiable evidence of their ability to pay their portion of the rent, which would be what in this situation? $200. So if the tenant has a part-time job and they're earning $1,000 a month, do they have sufficient evidence to show that they can pay the $200 a month? The answer is yes. And you will not be able to use their credit history to reject them because they can produce verifiable evidence that they're able to pay their portion of the rent. This is a new law. Many of you are relying on credit history. And this law, the public policy behind it is we want to allow those people who are economically disadvantaged but have a voucher or a third party to pay a subsidy to still be able to rent your unit if they can produce legal, verifiable evidence of their ability to pay the portion of the rent. Not the full rent, but their portion of the rent. I recently had a client who summarily utilized the tenant's application credit history to proactively reject the tenant, and the tenant informed them they had a voucher and they should not have just rejected them based upon the credit history. And we had to correct the communication and invite the tenant to provide verifiable evidence that's legal of their ability to pay that portion of the rent. SSI benefits, bank statements evidencing that they have sufficient funds in their account, and then payment stubs, work records that show they have those funds. Be careful. Remember, we do not summarily reject someone because they participate in a Section 8 program. A prospective applicant who comes to you and says, "Hi, I'd like to rent your unit. I want to know if you accept Section 8. What you need to do is always say, "We invite all applicants to apply. Please submit your application." You do not summarily reject that person by saying, "I'm sorry, we do not participate in a Section 8 program." That will get you sued. I've had many people in the Bay Area come to me and get sued after they say we do not accept Section 8. There is a single attorney who's doing very well simply testing landlords who are having a place for rent by having a testing prospective tenant ask the landlord if they're accepting Section 8. When the tenant says, "No, I do not participate in," when the landlord says, "No, I do not participate in Section 8, boom, 3 days later, a letter is sent to the landlord demanding 3 times the rent and $5,000 to settle the case because you have a violation of the law. So be careful. When in doubt, always invite everyone to apply for the unit. Such a minefield out there, and there are attorneys doing very well sending their kids to private school off of the mistakes that you make, because this area is very, very complicated. Never deny someone an application to apply simply because you say, "I don't participate in Section 8. Instead, say, "I welcome all applicants." AB 1620 modifies Costa-Hawkins Rental Housing Act. It specifically addresses people with permanent disabilities, and it allows a disabled person to secure alternative housing when they're in a situation where they need to be relocated within a building under the same rental rates and terms. Let's look at how this plays out. Just be advised, if someone's requesting an accommodation to be moved to another unit because of some physical condition that is harming and making it difficult for them to actually exist in their unit. For instance, you have a 5-floor apartment building. Tenant breaks their leg. They're on the 3rd floor. The breaking of their leg is severe. They can't go up the stairs. Questions to ask whether AB 1620 applies. Is the tenant's request for move determined to be necessary to accommodate the tenant's mobility-related disability? If the answer is yes, go to the next question. Is there an operational elevator that serves the floor of the tenant's current unit? If the answer is no, then you've got to go through the next step. Is the new unit in the same building or the same parcel with at least 4 other units under the same ownership? If the answer is yes, does the new dwelling or unit comply with applicable requirements of the Health and Safety Code? Has the applicable rent board determined that the owner will continue to receive a fair rate of return? Is the tenant current on their rent? If all of that occurs, then you're going to have to move that disabled tenant to another unit, another comparable unit on that lot because of the accommodation request. The goal and the public policy behind it is we don't want to hurt someone because of an injury or a disability. We want to lay the responsibility on the owner to try to accommodate that person by giving them like-kind housing inside that building at the same rent amount. Again, Many of you will not be aware of this. If someone makes an accommodation request because of a disability and they want to move to another unit into your property, please contact my office and we'll talk about it, and we'll go through this protocol, go through the questions, and make sure that we have the correct answer and the correct communication back to the tenant. If you summarily deny the tenant's request for the accommodation, you have a fair housing complaint. Those are very expensive. And I promise you, there are tenant attorneys who are going to represent people who are disabled, who an owner will reject a request to be moved into another vacant unit of building, and they will again get sued or will be having to address a fair housing complaint. And those can be very time consuming, complex, and cumbersome. This is very much like, and we've gone through this before, where a tenant says to you as they're applying for a rental unit, I have a emotional support animal. I want you to know about that. And you, in your ignorance, say, I'm sorry, this is a no pets building. What do you have when you say it's a no pets building after someone requests an accommodation because of an emotional support animal? You have a fair housing violation. You have a violation of the Americans with Disabilities Act. You have a violation of California Civil Rights Act. So you've got to be very smart about what you do and what you say. When in doubt, take a deep breath and contact my office. Remember, the mistakes you make after the fact, before you contact me, very hard for me to correct. SB 712, I call it Wheelmageddon. Tenants have a right to store their micromobility devices in rental units so long as the batteries meet certain safety standards. E-bikes, e-scooters, e-skateboards. You don't want them in your building. Too bad. SB 712 requires you to allow the tenant to store their devices inside their rental unit. There are some exceptions. Of course, the battery must be a approved safe battery. This next chart gives you the information about what batteries are appropriate. And the only other option to preclude a tenant from storing their e-bike, e-scooter, e-skateboard in their unit is the landlord providing tenants long-term storage outside of the unit. You can require a tenant to store their device outside as long as the following: access is limited within the housing complex. It is located on the premises. It is safe and secure and protected against precipitation. It has an electrical connection. For each micromobility device, tenants are not charged for its use. Can you believe this law? It looks like someone in the e-bike industry went to Sacramento and created a great statute to ensure that tenants are entitled to store their vehicles inside your rental unit, inside their rooms. And guess what? Which electrical are they going to be using? If you have a master metered electrical for your building, you're going to be paying for their charging. And I know from experience, tenants who are not careful can create fires as a result of their plugging in too many electrical appliances, e-bikes into a particular cord or a particular box, and a fire arises. I don't like this law. Unfortunately, I don't get to do anything except for tell you about the law and inform you to comply with the law, because if you don't, you create liability for yourself. Best bet is if you have a storage facility that meets these requirements, that actually has electrical inside, well, then direct the tenant to complete and move their vehicle inside that garage or that storage room. We do have an addendum that we prepared, and the California Apartment Association, I believe, or the San Francisco Apartment Association also created an addendum for this issue because it is big. The volume of electrical vehicles that are now, or micro vehicles that are now all over the place, are now going to be inside your buildings. Be careful. You want to be safe about it. AB 1765, not a big issue. It's beneficial to owners. You now are allowed to send a receipt for the screening report via email. Previously, you were required to hand deliver the receipt. Not a big change. It's a change that allows you to be more easily able to deliver the documentation required. After you take a screening report, you're able to send that receipt by email. SB 602, this is important. I can't tell you how many people have called me over the course of my career and say, hey, I have squatters living in my building. They broke into the building. The client calls me and says, I called the police. I met the police at the property, and the tenant showed the police an old lease agreement, and the police then declined to arrest them, declined to move them from the property, and said, I'm sorry, Mr. Jones, this is a civil matter. You'll need to take this up with an attorney. I can't remove them from the premises. That's frustrating, and that's how the police are typically taught. They're taught to treat disputes involving housing through civil matters where they hire me, your owner, to do an effective eviction action or an unlawful detainer action, when it would have been so much easier if the police did their job, and if someone in fact was a trespasser or a squatter and did not have tenancy rights, they actually would remove them from the premises. At this point in time, you're now in a situation where, as long as you provide this type of letter to the police, you're going to have a better chance of having them removed from the premises by the police, as opposed to having going through the civil process. My general advice is, where you have someone who is actually squatting in a unit or broken into a unit, instead of calling the police, call 911. Call 911 and say, I have an active break-in into the property, and then go to the property, and then ask for the person to be arrested for trespassing or burglarizing the property. If that is the truth, that is a more likely chance that the police will remove them. If you call a police station and then you meet the police, they may decline to do anything because the person inside the premises will say, I'm sorry, but I've been living here for 6 months, and they will give a bogus reason, and the police will say, I'm sorry, but I'm not going to do anything at this time. You'll have to take this up with an attorney. And then you have the frustration of having to hire an attorney to deal with a eviction action, which should be better treated as a trespass, a violation of the criminal statute, and the removal. Anybody who has any questions regarding this, please just contact me, email me. I'm always available to help. I see on this list of attendees, we have over 200 people here. Many of you are existing clients or have worked with me before, and you know I'm happy to help you out, happy to figure out a problem or tell you I don't have a good solution. Most importantly, you recognize I don't have a monopoly on judgment. If you talk to 2 attorneys, you may get 3 opinions. Some attorneys are not aggressive. Some attorneys are scared of their shadow. Some attorneys are more aggressive, and you have to decide which attorney you're comfortable with, but always get a second opinion if you're not comfortable with the advice you're being given. Now, I have talked to you earlier about the fact that local ordinances that are more restrictive have more challenges for housing providers. And we all know in San Francisco, in Berkeley, in Oakland, in Richmond, we are faced with a more restrictive ordinance. And be advised, Emeryville has an ordinance. Hayward has an ordinance. Concord has an ordinance, and they're discussing new provisions to the Concord ordinance. Pittsburgh, Antioch, all over the Bay Area, there's new ordinances. Let's go over some of the more restrictive rules that are arising in some of those areas that most of us have real estate in. So Oakland, it used to be that San Francisco had the most pernicious ordinance. Now Oakland is starting to look more pernicious than San Francisco. Oakland has tweaked a few of their regulatory regimes. I'll point out a few of them. It used to be a tenant had to be current in their rent to file a petition at the rent board. The answer is no, they no longer need to be. A tenant now can have a decrease in housing service up to 36 months. Rent board appeals before the rent board commissioners is now 6 months, 6 minutes, not a big deal. The appellant does not have to appear. Right now in Oakland, rent increases are capped at a allowable amount without banking until July 1st, 2024. The most pernicious aspect in Oakland right now is the top right-hand side. You cannot evict a tenant where the amount of rent is demanded is less than 1 month of the fair market rent per unit of equivalent size in Oakland. What does that mean? So we have studios, 1 bedrooms, 2 bedrooms, 3 bedrooms, and 4 bedroom units. In Oakland, if a tenant is renting a 1 bedroom unit and their rent is $1,000 and they didn't pay it for January, prior to this new law, I could turn around and serve a 3-day notice to pay rent or quit for $1,000 because they owe $1,000 and haven't paid January rent. Now in Oakland, before I can serve a 3-day notice for an Oakland just cause eviction unit on a 1 bedroom, the tenant has to have a debt in excess of about $1,969. So for that example of the tenant whose rent is $1,000 a month, I have to wait until February before I can demand the rent, because now the tenant would owe 2 months rent, $2,000. So in Oakland, for a studio, you have to have a debt equivalent to $1,658, a 1 bedroom, $1,969, a 2 bedroom, $2,405, a 3 bedroom, $3,144, and a 4 bedroom, $3,706. Before this law came into effect, if a tenant owed you $100 in unpaid rent, you could serve a 3-day notice. Now you have to wait until that threshold amount is reached before you can serve a 3-day notice. It's absurd. It holds and puts 100 years of landlord-tenant state law upside down, because now we first have to check to see what size of the unit, 1 bedroom, 2 bedroom, 3 bedroom, studio, or home, and how much the debt is, and it has to reach a certain level before we can serve a 3-day notice. How many people in Oakland know about this? Probably if you ask 100 people, maybe 3 people know. Housing providers have to know this. I have clients coming to me and sending to me their 3-day notice they prepared. And the first thing I have to ask them is how many bedrooms? And they prepared a 3-day notice for a 3-bedroom unit because the tenant owed $2,000. And I say, I'm sorry, that 3-day notice is no good because you need to have $3,144 owed before we can demand that rent. This is Oakland. Welcome. San Francisco has not gotten to this point yet. Another point, lease breaches must create injury. They must be reasonable, substantial, and there must be a breach that's agreed to in writing. I can only tell you this. Oakland is proving to be more difficult nowadays than San Francisco. Let's go to San Francisco. Well, we have a new ordinance that's being chewed upon. It's not signed into law, that allows tenants to bypass DBI, not DPI, I apologize, and sue the landlord for substantial substandard conditions. It's not law yet, but it's an invitation for more litigation. Stay tuned. I will continue to keep people updated as this law progresses, but I want you to understand that there is a real risk that this new law will invite even further litigation in San Francisco. The best suggestion is, if you own property in San Francisco, keep it in good condition. If a tenant has a legitimate request for repair, get it fixed. Do not sit on a repair. Do not sit on a water intrusion issue. Do not sit on a broken window. You want to be proactive. You want to inspect the units, because if in fact this law comes into effect, we're going to have more litigation against those people who have been delayed in their completion of legitimate repair requests that needed to get done yesterday and are still existing. In San Francisco, security deposit interest is 5.2. Rent increases for March through February 2025, 1.7%. There will be new rules that involve e-bikes and e-scooters. Many of you know there's a vacancy task. There's a lawsuit currently in challenging the vacancy task. And now there is the right of tenants to create unions within your building. And then you have to give credence to that union and have meetings with the union. And if you fail to do so, you can be subject to a decrease in service petition. I am now intermittently showing up as owner's counsel during union meetings where I'm listening to tenants and their union quote unquote representative and all the concerns they have. And I have to engage in good faith communication with them to address issues at the building. And it's as if I'm involved in a collective bargaining environment with a group of tenants. If you ignore the tenant's right to establish an association, you can be subject to litigation and subject to a decrease in service petition. Remember, both in San Francisco and in Oakland, there is a rent registry. If you are not registering your unit, you will not be able to get a rent increase if it's challenged. You must have the license that registration provides that gives you the license to raise the rent on those properties in San Francisco that are subject to the rent control ordinance. Without the license, the rent increase is no good if challenged. Let's move on. I always provide this chart for those new people who are joining a seminar by me or a webinar for the first time. This law hasn't really changed. This is the chronology of the eviction process. There's been slight modifications, but not really. The one thing I will say is under state law, Berkeley law, San Francisco law, before you can serve a cure or quit notice for a lease violation, typically you have to first give them a 10-day warning notice. But other than that, the eviction process remains the same. The whole goal when you hire an attorney to do an eviction or an unlawful detainer, the tenant is unlawfully detaining possession of the premises, is to secure the vacancy as fast and as cheap as possible, taking into account attorney fees, time, and risk. Before I get started, inevitably a client will say to me, Mr. Bornstein, how much is this going to cost? How long is it going to take? The first thing I say is, I don't know. The biggest variable I have no control over, which is which attorney the tenant gets and how hard they fight. That will fundamentally determine how much it's going to cost and how long it's going to take. I have no control over that. And to add insult to injury, tenants get free attorneys. Your tenant can be a Google executive. They're entitled to a free attorney in San Francisco. Tenants get free attorneys in Alameda County. At the settlement conferences, there's a table of attorneys, and the judge informs the tenants before the settlement conference, if you don't have an attorney, you can get one to help you with the settlement conference. So everybody's being given representation. If they're at least proactive enough, they'll have an attorney, which means the cost will go up. Generally speaking, prior to COVID, when people would ask me, how long is this process going to take after the lawsuit's filed? I would say 8 to 12 weeks, 2 to 3 months. Sometimes it's shorter, sometimes it's longer. I've had to modify that time period post-COVID because of the nature of the courts. And now when people ask me how long it's going to take, I say 12 to 16 weeks. Sometimes it's shorter. Generally, it's within that 12 to 16 week process to recover possession of the premises or at least settle the case. Now, this is after we have filed the lawsuit, not at the start of this. So for instance, if you're a new buyer and you want to do an owner move-in termination and the tenant's lived there over a year, we first have a 60-day notice. So it's 60 days termination notice. If the tenant doesn't move out, it's another 3 months to maybe 4 months before you recover possession of the premises. So if you buy a property and you're going to do an owner move-in eviction and you say, Mr. Bornstein, how long is it going to take? I say, I hope it takes 60 days and the tenant moves out. But if they don't move out in 60 days, we're looking at another 3 to 4 months. And the client says, well, how am I going to afford to pay a mortgage, pay my rent, pay relocation payments, and pay you, Mr. Bornstein, for your attorney fees? And I only can say, I don't know, but you need to find a way to do it, or you're going to be sitting in your rental unit waiting to get back into your purchased house without a solution. So you've got to be well funded. And I've had clients undercapitalized when dealing with litigation, and undercapitalization for an eviction action is very, very stressful for people. So you do need to have resources in order to accomplish your goal, because it can become expensive and cumbersome and very stressful. My job is to be direct, clear, and transparent. And my job is always to not give you a false sense of security, but to give you a real good reading of the lay of the land. And that's my promise to all of you. Status of the courts. I can only tell you post-COVID, things are moving and the courts are open. But I will tell you, for instance, I was in Alameda courts about 3 weeks ago on a settlement conference for an unlawful detainer action, and there were 90 cases on that calendar. 90 cases. It took the judge an hour and a half just to go through the names of all the people that were part of this calendar. So things are very delayed. And when it means that there's a volume of cases, if they go unresolved because you were not able to settle the case, there are not enough courtrooms available to get you into a courtroom to get your trial. And that inertia serves the tenant's interest, because an unresolved case that's sitting with a waiting list for a courtroom means the tenant's not paying the rent because you can't collect it during the eviction process. The tenant's enjoying the benefit of the housing and you're waiting to get closure. And rest assured that inertia is exploited by the tenant defense community, because a day without resolution is a day inside your unit. So all I can say is the courts are stuffed up. San Francisco is functioning more rapidly than the Alameda County. Contra Costa is more rapid. Another caveat, I got a judgment against a defendant in a case in Alameda County. I got a judgment at the beginning of January. You know when the sheriff's eviction was scheduled? The first week in March. 2 months to get the eviction sheriff to actually evict. You're sitting with a judgment and you're waiting 2 months to get the actual person removed from the premises. Welcome to the Bay Area. Welcome to post-COVID landlord-tenant law. To add insult to injury, what used to be a 2-week, 3-week waiting process in Alameda County is now 2 months. I just scheduled another one up the end of March. That's frustrating for a client. Can I do anything about it? No, the sheriff sets the schedule. There's nothing I can do. San Francisco, fortunately, doesn't have that problem. We're still about a 3-week time period between the time the judgment is entered and the sheriff goes out. But this is a reflection of our government apparatus is tasked with work that it can't get done because of administrative personal delay and because the volume of pent up cases that exist because of the COVID pandemic. Nothing I can do. All I can do is tell you the problem, which leads me to recognize that this is likely to only get worse. More cities are enacting rent control within their jurisdictions. It doesn't necessarily stabilize housing. It serves in my mind, a small group of people very well, long-term tenants, but it ends up costing people more money in rent for those vacant units. And then to add further distress, many of you may be aware that we are facing a ballot initiative to get rid of Costa-Hawkins or to minimize it, which may mean that vacancies will not result in decontrolling a unit for rent, that local jurisdictions will be able to put further regulations so that you could not charge fair market rent for a vacant unit. Be advised, the Justice for Renters Act is on the November ballot. You will be besieged as a housing provider or someone in the real estate industry to contribute to oppose this ballot initiative. And I strongly advise you to consider making a contribution, because if this law passes, it's going to have a terrible impact on property owners, housing providers, because it will further constrain your ability to get fair market rent for your property, despite the fact that utility bills are increasing, despite the fact that contractors and maintenance are increasing in cost, despite the fact that taxes are increasing, despite the fact that the ability to purchase is more expensive. You will not be able to get the same type of rent if this Justice for Renters Act passes. I will be personally sending out requests for my client network to be making contributions to oppose this. In the past, at the state level, we have successfully opposed this ballot initiative. We need to do it again. With all that said, and all of the terror and trauma of having to go through an unlawful detainer action or an eviction action, my strong advice is, if you have a dispute and you can negotiate a voluntary move out of the premises by the tenant, do so. We are doing a lot of negotiated voluntary move outs. My strong preference, if you have to pay an attorney $5,000, but you could pay a tenant $5,000 to move out, or $5,000 for the attorney to start an eviction process, I would pay the tenant the $5,000. Not because it feels good, but because it's good business for you. Our office is providing buyout agreements throughout the Bay Area. We do so in all different jurisdictions, but be advised, buyouts are different depending upon the jurisdiction. Berkeley has a different rule. San Francisco has a different protocol. Oakland has a different protocol. For instance, in San Francisco, despite signing the agreement, the tenant will have 45 days to change their mind. In Berkeley, a tenant will have 30 days to change their mind. In Oakland, it's 30 days unless the tenant, or 25 days unless the tenant agrees to have it shortened to 15 days. There's certain document requirements that are different, but rest assured our office is comfortable in drafting these agreements, and we're doing so because it makes good sense. Whether you're trying to sell a property vacant and you're offering money to a tenant to move out before you market the property for sale, whether you have a tenant who's not paid the rent and you don't want to proceed with an eviction, you'd prefer to waive the rent and have them voluntarily move out, buyout agreements make sense. Work with an attorney to make sure you're doing it code compliant. You're not just giving tenant money to move out, you're giving tenants money to move out and also agree to waive all claims arising out of their tenancy. So you're getting no residue after they vacate. This is important. For example, if I proceed in a non-payment of rent eviction against a tenant and I win a trial, the tenant is evicted and they owe you money. However, the tenant fell down your stairs and broke their leg. After they're evicted, could the tenant sue you for having hurt themselves as a result of your stairway? Yes. If a tenant has a respiratory illness because of mold, despite the fact that they got evicted for a non-payment or rent eviction, they still have a cause of action against you for having a respiratory illness that arose as a result of your mold inside the unit. If you do a properly prepared tenant buyout agreement, the tenant is moving out. They're giving up all claims they know about, including those claims they don't know about. So when they move out, there's no residue. There's no risk of further litigation if done correctly. That's why my strong preference is to reach agreements as opposed to get involved in litigation with tenants. So keep that in mind as you start to deal with potential disputes with your tenants. It's my pleasure to help out. It's, as I always say, a privilege to provide information and guidance to you. I will say to you, if you have questions, by all means, email me. If the question is easy, I can respond quickly. If the question precipitates a need to have a meeting, I'll let you know. Please distribute the PowerPoint slide presentation. Also, please continue to be part of my social network. I send out e-blasts quite a bit to update you with new laws. I will inform you of new laws as they arise. And it's my pleasure to educate. It's something I'm very proud of doing. And my whole goal is to help you learn what you know and to reduce the complexity of this to a working knowledge with a big caveat. The stuff is complex. And what I present to you is not the full story, but it gives you a good understanding of what we are up against. And it's my hope that this was helpful to you. For any of you who want further clarification or further documentation, just reach out to me. I want to thank you all for your attention. And I want to, again, thank you for being my client, being a potential client. And even if you're not a client and you're here simply to educate yourself, thanks for participating. It is, again, a very tricky area. And I can only tell you, tread carefully, contact an attorney if you have a problem before you get yourself in a worse situation. So with that, I'm ending. I want to wish you all a wonderful and healthy 2024. I hope trends are such that though things are getting more difficult, your particular real estate investments are something that are financially beneficial and more rewarding to you. Thank you very much.